Okay, it's 10 o'clock. Good morning, everyone. This meeting is called to order. Ms. Trotman, does anyone sign up for public comment?
Good morning, Commissioners. Les Trotman, General Counsel. We do have one individual registered for public comment this morning. We have Ketra Hunter. Ms. Hunter, if you could unmute yourself and then begin.
Hi, my name is Ketra Hunter. How is everyone doing?
Great. Go ahead, proceed.
So I just wanted, I was given the chance to speak about why I was late calling in for my initial meeting with unemployment. And it's really, I've already submitted the paperwork. It's really when I was sent the paperwork, my daughter was having a medical emergency. She was back and forth to the doctor several times and she had to have an emergency procedure. And then 3 days after that, my mother was also had to have not emergency, but my mother had surgery. And I was just, when I received the paper from unemployment, I just noted the time and the date, and that was really about it. Like I said, I was just going through, well, my daughter and my mother were just going through some medical issues. And by the time I recognized my my mistake, I did put, I believe I put in a good faith attempt to call, because if you check, I called in at 11:01. I was a few minutes late calling in, but I do not feel like that should be why my unemployment has been stopped.
Okay, thank you, Ms. Hunter. Appreciate that. Commissioners, that's what we have for public comment this morning.
Very good. Now turn over the meeting over to Commissioner Conant, preside over agenda items 3 through 8. Mr. Conant.
Very good. Thank you, Chairman. Good morning, Ms. Miller. I
Good morning.
understand that we have no cases to reconsider under agenda item 3. Is that correct?
Correct, no cases.
Under agenda item 4, tax liability cases. Good morning, Mr. Daniel. I understand that we have no tax cases on dockets 2 and 3, but there is one tax case on docket 4. Is that correct?
Yes, that's correct. For the record, Hugh Daniel, Special Program Appeals. That's correct, Commissioner Conant. There's one tax liability case in docket 4 and no tax liability cases on dockets 2 and 3. The case number on docket 4 is TD-25-011-0925. Chairman Esparza.
Agree with the recommendation.
Commissioner Trevino.
I agree with staff's recommendation.
Commissioner Conant.
Agree with staff recommendation.
Thank you all. That concludes tax liability cases for these dockets.
Moving on to agenda item 5, I understand we have no fair housing cases, correct?
Correct, no cases.
And on agenda item 6, we have no child labor cases on dockets 2, 3, or 4.
Correct, no cases.
That brings us to consideration of wage claim cases under agenda item 7. We have no wage claim cases pulled for additional discussion on dockets 2, 3, or 4, correct?
That is correct. None pulled for additional discussion. However, you should have received the wage claim short form dissent list for dockets 2, 3, and 4.
Correct. I'm in receipt of that. I move that we accept staff recommendations on the remaining wage claim cases on dockets 2, 3, and 4.
I second the motion except for those cases which I am dissenting as reflected on wage claim short form dissent list for docket 2, 3, and 4.
I concur with the Commissioner's motion, except for the cases on which I'm dissenting is reflected on wage claim short form dissent lists for dockets 2, 3, and 4.
The motion passes with the exceptions noted. We move now to agenda item 8 in consideration of unemployment insurance cases on dockets 2, 3, and 4. Please proceed with docket 2 whenever you're ready.
Thank you, sir.
Case number 3287231, Commissioner Trevino.
The decision is not supportable. The claimant testified that she never received a document instructing her to provide proof of employment, so she was unaware of that requirement. When the determination was issued, the claimant filed a timely appeal and offered to provide any necessary information, but as she had never received the original request, she didn't know what was required. The commission then delayed scheduling a hearing, in this case for over 2 years. When the hearing was finally scheduled and the issue was explained to the complainant, she provided the requested documentation. Since the commission delayed scheduling the hearing for over 2 years after the claimant's timely appeal, we should not hold the claimant ineligible for failing to provide proof of employment documentation in a timely manner. Reverse the AT, claimant PUA eligible beginning 12/27/20. No overpayment.
The AT decision should be affirmed. The claimant was sent documentation to provide proof of employment. However, the claimant did not provide the required proof in a timely fashion. Claimant also noted that it was possible the documentation to provide proof of employment may have been thrown away. As such, we should affirm the AT decision. PUA not eligible beginning December 27th of 2020, overpayment.
The claimant's good faith speculation that someone may have thrown away the notice at issue is not enough to deem her testimony unclear or inaccurate. Further, no evidence suggests that the claimant was sent another copy of the notice after she informed TWC that she did not receive it. As such, we should extend the response deadline due to notice of non-delivery and reverse the PUA ineligibility determination and corresponding overpayment as the requested documents were eventually received during the appeal process. Reverse the AT, claimant eligible for PUA benefits, no overpayment.
A short form consent.
Yes, sir.
Case number 3605693, Chairman Esparza.
I agree that the employer had good cause for its non-appearance. However, as to the merits, a rehearing should be conducted in this case. The employer and claimant were not asked about standard operating procedures as it relates to the final incident. As there is a lack of evidence regarding the final incident, this case should be reheard to allow the parties an opportunity to provide testimony about the standard operating procedures and policies. The employer had good cause for its non-appearance. Reheard.
AT decision should be modified. We previously voted that the employer established good cause for its failure to appear at AT1. Regarding the job separation, the claimant was discharged for failing to follow the employer's standard of operating procedures and failing to properly document audit procedures. However, the claimant provided credible and consistent testimony denying that he made any mistakes or failed to follow any known procedures, while the employer's allegations were only based on secondhand hearsay testimony. Therefore, the employer failed to meet its burden of proving that the claimant was discharged for misconduct connected with the work. Modify the AT, employer established good cause for AT1, no misconduct, chargeback.
Good cause should be found, and this case should be reheard. The hearing officer did not question either party as to whether a new standard of procedure existed, what this procedure entailed, when it was implemented, and whether the claimant knew or should have known about the new procedure. Additionally, if it exists, documentation of the new procedure should be submitted into evidence. Modify the AT, good cause, rehear.
We will rehear the case.
Case number 3713298, Chairman Esparza.
The AT decision should be modified. While the claimant denied wrongdoing regarding the employer's conflict of interest policy, it was ultimately his operation of his side business that resulted in the employer being named in a lawsuit. It was a claimant's side business, so it is not unreasonable to conclude that it was the claimant's decision to choose which clients to engage with. The claimant bears the responsibility for the decisions that result from the management of the side business, and one of those decisions was choosing to do business with another entity that ultimately sued the named employer, costing them tens of thousands of dollars in legal fees. As such, the claimant's action constituted misconduct connected with the work. We should therefore modify the AT decision, misconduct, no chargeback, sever adequate employer response. In the alternative, I could also support a vote to rehear the case to enter the employer's additional documentation into the record for the employer to authenticate said documentation and to take testimony for the parties regarding the same. Rehear.
The AT decision is not supportable. The employer discharged the claimant for an alleged conflict of interest violation after both the employer and the claimant's side business were named in a lawsuit. While the lawsuit alleged that the claimant promised the plaintiff that the employer would hire them as a subcontractor, the claimant denied this under oath and testified that this was a frivolous lawsuit bought in retaliation after he sued the plaintiff business for non-payment. The employer agreed that the claimant having a side business did not violate their policy, and the employer had no direct knowledge or evidence regarding the allegations. Additionally, while the employer also alleged that the claimant had improperly used the company's credit card, they did not present any direct evidence of this and only raised the issue after the separation. The claimant both denied the allegation and provided legitimate explanations for the business-related charges. Therefore, the employer has not met its burden of showing that the claimant engaged in any action that constituted misconduct connected with the work. Reverse the AT, no misconduct, chargeback, void adequate response.
The claimant should be disqualified. Specifically, as it relates to unemployment insurance law, the evidence suggests that the claimant violated the employer's policy and was discharged for misconduct. Modify the AT, misconduct, no chargeback, sever adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3829914, Commissioner Trevino.
The decision should be reversed. The employer discharged the claimant and alleged that she was insubordinate in failing to follow her supervisor's instructions regarding a home sale and also discussed confidential information with the client. Regarding the allegations of insubordination, the evidence established that the claimant did not refuse to follow the supervisor's instructions, but merely asked for further clarification of the instructions by requesting to see an email showing the other employee was working on the sale. Regarding the confidential information issue, the employer's allegation of the claimant repeating a comment made by her supervisor to a client were based merely on hearsay testimony and conjecture. Therefore, the employer has failed to meet its burden of proving that the claimant engaged in actions that could be considered misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
The AT decision should be affirmed. The claimant was attempting a sale of a home in a neighborhood she was not assigned and to a customer she was not assigned, despite being put on notice that this was not her area of coverage or her customer. Following this insubordinate behavior, she violated confidentiality policy after disclosing private information given by management to the customer. As such, the claimant violated policies of the employer amounting to misconduct connected with work, and we should affirm the AT decision, misconduct, no chargeback.
The claimant should be disqualified from the receipt of benefits. The claimant engaged in misconduct when she, 1, refused to remove herself from a sale as instructed, despite the employer having sole discretion over sale assignments, and 2, revealed confidential information to a client. Therefore, affirm the AT, misconduct, no chargeback.
Short form dissent.
Yes, sir. And that was the last case pulled for additional discussion on docket 2. You should have received the UI short form dissent list for docket 2.
I move that we accept staff recommendations on the remaining UI cases on docket 2.
I second the motion except for those cases which I am dissenting, as reflected on UI short form dissent list for docket 2.
I concur with the commissioner's motion, except for the cases of which I am dissenting is reflected in UI short form dissent list for docket 2.
And the motion passes with the exceptions noted.
Thank you. Continuing to docket 3.
Case number 3702804, Chairman Esparza.
The AT's decision should be modified. The claimant was discharged after his violation of school policy on restraint of students. Claimant was aware of this policy and did not conduct himself in accordance with school policies. As such, the claimant mismanaged his position of employment, amounting to misconduct. Modify the AT decision, misconduct, reimbursing employer not billed, sever adequate employer response.
The AT decision should be reversed. The claimant, a 16-year employee of a public school district, was discharged for allegedly violating the employer's physical restraint policy based solely on a portion of a video of the incident, which did not include sound or demonstrate the full context of the incident. The witness statements, including a letter from the father of the student involved in the incident and a letter from the local police department, all supported the claimant's testimony that he was responding to a student who acted erratically, threatened the complainant and others with physical harm, and initiated physical contact with the complainant, and that the claimant's actions of physically restraining the student to protect the claimant, the student, and others were appropriate given the circumstances. Therefore, the employer has failed to establish that the claimant's actions are misconduct connected with the work. Reverse the AT, no misconduct, bill reimbursing employer, void adequate response.
The claimant should not be disqualified for misconduct. The evidence suggests that the claimant reasonably employed his previous job experience to restrain a student who was known to act violently, had been threatening his teacher and other students, and had just attacked the claimant. Further, the employer has not carried the burden of proving that the claimant was ever trained to react differently. Modify the AT, no misconduct, bill the reimbursing employer, void adequate employer response.
Short form of second.
Yes, sir.
Case number 3706127, Commissioner Trevino.
The decision is not supportable. The employer, a defense contractor, charges the complainant due to its inability to obtain the necessary security clearance required for a special project that he was hired to work on involving classified information. The complainant submitted the application for the required clearance, which he previously had when he worked for the employer before. However, the government denied the claimant's clearance application without providing any explanation for the denial. Since the employer could not have the complainant continue on the project without the required security clearance, and because there was no evidence that the claimant did anything to cause the denial, the complainant's separation was required by operation of law and the reasons other than misconduct. Reverse the AT, no misconduct, no chargeback, separation required by operation of law.
The AT decision should be affirmed. The claimant and the employer entered into an agreement where the claimant's role was contingent on obtaining the necessary clearance. As the claimant was unable to secure this in a timely fashion, the requisite for employment was not met, constituting mismanagement of his position of employment amounting to misconduct connected with work. Affirm the AT decision, misconduct, no chargeback.
The claimant should be disqualified. Precedent clearly establishes that it is a mismanagement of one's position to fail to meet an agreed upon requisite requirement. Though this case is somewhat distinguishable since it's not clear whether the claimant's actions caused his inability to obtain the required clearance. However, because the claimant ultimately had more agency and control over his ability to obtain clearance relative to the employer, misconduct should be found. Affirm the AT, misconduct, no chargeback.
Misconduct, no chargeback.
Short form dissent.
Yes, sir.
Case number 3707596, Chairman Esparza.
The AT decision should be reversed. The claimant was discharged after violating the employer policy regarding consuming alcohol at the workplace and pouring the establishment's liquor after hours. Conduct that could have jeopardized the employer's license. Since this was against the employer's policy, the claimant's actions were mismanagement of his position of employment amounting to misconduct connected with work. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response.
The AT decision is supportable. Although the claimant was discharged for drinking at the employer's establishment, sports bar, while off the clock and after hours, it was clearly established that it was common practice for employees, including management, to engage in this behavior. The claimant had no prior warning of this type of issue, and the employer did not present any policy on the matter, and various others who had engaged in this behavior still currently work for the employer. Therefore, the employer did not meet its burden of showing that the claimant was discharged for misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
The claimant should be disqualified. The employer should not be penalized for its good faith attempt to enforce state regulations limiting the service of alcohol. As it relates to the context of unemployment insurance, the claimant's actions constituted a mismanagement of his position by potentially jeopardizing the employer's liquor license. Modify the AT, misconduct, no chargeback, adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3714548, Chairman Esparza.
The AT decision should be reversed. The claimant was discharged for leaving work 1 hour before her shift ended and failing to clock out, despite having been warned about excessive absenteeism. Claimant's credibility diminishes due to conflicting testimony she provides. In her fact-finding statement, the claimant stated that she left at 4 p.m. In later fact-finding, the claimant stated she doesn't remember when she left. Finally, in hearing testimony, the claimant testified she left at 3:45 In essence, the employer's testimony must be given greater weight. As the claimant left the job before the end of her shift, she mismanaged her position of employment, amounting to misconduct connected with the work. Versus the AT decision, misconduct, no chargeback, adequate employer response.
The AT decision is supportable. The employer discharged the claimant for allegedly not requiring or reporting an injury in a timely manner and for leaving work early. However, the employer did not provide any firsthand testimony on either matter, and the complainant's credible firsthand testimony established that she did not realize that she had suffered an injury until a few weeks later, when her shoulder started to hurt and she went to her doctor. Once she got the diagnosis, she reported it to the employer. The claimant also testified that she got permission to go to her car to get a phone charger because the employer had instructed her to watch safety videos on her phone. This was shortly before her shift was over, and by the time that she had returned from her car, everyone else was leaving for the day, so she did too. Therefore, the employer did not meet its burden of proving that or showing that the claimant engaged in misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
The claimant should be disqualified because she left work early and failed to properly clock out after receiving a final warning for failing to timely report a workplace injury. Modify the AT, misconduct, no chargeback, adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3731841, Commissioner Trevino.
The AT decision should be reversed. The claimant worked for a call center, and after 2 years, the claimant's position was changed. Due to the change in his work duties, the claimant had to ask more questions of his team leads, which required him to place customers on extended holds. The claimant testified that though the employer had a policy requiring employees to check back with customers who were on hold for over 2 minutes, there was an exception for cases where the customer was informed that he was reaching out to a lead for assistance. Since the complainant was learning a new position and there was no evidence that the claimant was intentionally avoiding calls by placing customers on hold, the employer has failed to establish that the claimant was discharged for misconduct connected with the work. Reverse the AT, no misconduct, chargeback, void adequate response. In the alternative, since the policy documents were provided for the hearing were illegible, and the hearing officer made no attempt to obtain legible copies of the documents, I could agree to rehear this case to obtain legible copies of the policy documents and further question the parties regarding their employer policies.
The AT decision should be modified. The claimant was discharged for violating the employer's policy on call avoidance. The employer stated that the claimant had received a final warning regarding call avoidance. Nonetheless, come on.
Thanks, sorry.
Nonetheless, the final incident consisted of the claimant incurring excessive hold times with customers and not following up with them in a timely fashion to provide progress updates. As such, the claimant's action amounted to misconduct connected with the work. We should therefore modify the AT decision, misconduct, no chargeback, sever adequate employer response.
Thanks. Sorry for the interruption, Chairman. The claimant should be disqualified. The claimant's testimony suggests that he continued to place customers on extended holds and failed to check in with them regularly, despite having received a final warning for this behavior. As such, the claimant violated specific instructions of the employer and was terminated for misconduct. Modify the AT, misconduct, no chargeback, sever adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3747827, Chairman Esparza.
The AT decision should be reversed. The claimant and coworker were both terminated for fighting at the workplace. The AT's decision findings of fact indicate that the coworker initiated the altercation and that the claimant then fought back in self-defense. However, as to the only party to attend the hearing, the employer provided sworn testimony subject to cross-examination that the claimant should have reported the incident to HR immediately. Instead, the claimant confronted her coworker, which ultimately led to the altercation. Because the claimant was unaware was aware that the employer had a zero tolerance policy for fighting at the workplace, and because the claimant confronted her coworker rather than reporting the incident to HR, her actions constituted misconduct connected with the work. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response.
The decision is correct. The employer discharged the claimant after she was involved in a physical altercation with another employee. The employer alleged that the claimant's actions violated their zero tolerance policy for fighting in the workplace. The employer testified that the claimant was not the aggressor and that she only made physical contact with the coworker so that she could defend herself. Since the claimant was not the aggressor and her coworker was the one who had instigated the confrontation, which turned physical, the claimant was separated for reasons other than misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
The claimant should be qualified. It appears the claimant in this case acted in self-defense. As such, we should not penalize the claimant since she did not voluntarily engage in a violation of the employer's workplace violence policy. Affirm the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir.
Case number 375. I'm sorry. Case number 3755262. Chairman Esparza.
The AT decision should be modified. Regarding good cause, the employer witness stated that it could not attend the hearing because the employer was closed. In addition, the employer's timely petition to reopen states that the employer called the hearing officer for the hearing to provide notification that the employer would not be able to participate. As such, we should modify the AT decision. The employer had good cause for its non-appearance. Resubmit.
AT decision is supportable. The employer testified that they failed to appear for the AT1 hearing because they are closed for business every Friday during the summer. However, the employer did not present any testimony or evidence to establish that they had informed the TWC that they were unavailable for the hearing scheduled on a Friday. Therefore, they did not establish good cause for their non-appearance. As to the underlying reimbursement issue, the available evidence does not include any explanation for the claimant's separation from employment. Therefore, there is no reason to disturb the initial determination that billed the employer's account. Affirm the AT, employer failed to establish good cause for AT1, bill reimbursing employer.
Good cause should be found, in this case should be resubmitted. The employer gave a reasonable and persuasive justification for why it could not attend the hearing on the scheduled date. Moreover, the employer credibly stated that it attempted to call TWC before the hearing to inform the agency of this fact. Modify the AT, good cause, resubmit.
We will resubmit the case.
Case number 3788539. Commissioner Trevino.
The decision should be modified. I agree that the claimant established good cause for his failure to appear at AT1. Regarding the job separation, the claimant's additional claim involved his work for a marketplace contractor in self-employment. As such, there was no separation from employment and the additional claim should be voided. Modify the AT, claimant established good cause for missing AT1, set aside the AT decision, void the initial claim. Alternatively, since the commission has regularly voted this way in similar cases, I move that we consider adopting this case as a new precedent to be included in the precedent manual in order to ensure consistency in agency decisions making, and to also formalize the principle that after a claimant files an initial claim, a continued claim should not be established based on work that the claimant has performed as a marketplace contractor. Therefore, I would request that the case be resubmitted so that this matter can be discussed at the next scheduled commission meeting.
The AT decision should be affirmed. I don't contest the good cause ruling. As to the job separation, the claimant could not continue working for the named employer due to problems with his mode of transportation. This constitutes a personal reason and not good cause connected with work for quitting. We should therefore affirm the AT decision. The claimant had good cause for his non-appearance, voluntary leaving.
Commissioner Trevino, I'll concur with your vote to resubmit in an effort to potentially consider updating our precedents and practices.
Thank you.
We have a majority vote to resubmit to consider for future precedent status. At this time, I have not registered a majority vote on the merits, so that can be handled next time.
Thank you.
And that was the last case pulled for additional discussion on docket 3. You should have received the UI short form dissent list for docket 3.
I move that we accept staff recommendations on the remaining UI cases on docket 3.
I second the motion, except for those cases which I am dissenting as reflected on UI short form dissent list for docket 3.
I concur with the commissioner's motion, except for the cases of which I'm dissenting as reflected in UI short form dissent list for docket 3.
The motion passes with the exceptions noted.
Thank you. Continuing to docket 4.
Case number 3755835, Commissioner Trevino.
While the claimant filed late appeals to the AT, this case involves a continued claim related to the claimant's working as a marketplace contractor in self-employment. As such, there was no separation from employment and the continued claim should be voided. Timely claimant petition to reopen, timely claimant appeal, set aside the AT decisions, void the continued claim.
The AT decision should be affirmed. The claimant filed his petition beyond the applicable deadline to be considered timely, and there are no good cause exceptions to the timeliness rules. As such, the claimant's petition should be dismissed as late. We should therefore affirm the AT decision. Untimely claimant petition to reopen, untimely claimant appeal, voluntary leaving, overpayment.
We should resubmit the case to summarize the entire record so we can better analyze whether the merits affect the timeliness issue. The available evidence on the underlying issue suggests that the claimant may have worked temporarily as a gig worker while searching for other work. This could mean that the claim is void from its inception, in which appeal time limits would not apply. Resubmit to summarize the underlying merits testimony.
Ma'am, I'll agree with Commissioner Connett to resubmit.
We will resubmit the case.
Case number 3770128, Commissioner Trevino.
The AT decision is not supportable. Although the claimant registered late for the AT1 hearing, he has consistently explained that this was because he was dealing with the death in his family the morning of the hearing and was on a family call about the matter at the time of the hearing started, which resulted in him missing the hearing. Since the complainant missed the hearing for a compelling reason that was beyond his control, he should be granted good cause for the non-appearance and the case resubmitted for merits testimony from AT2. Reverse the AT claimant had good cause for AT1, resubmit.
The AT decision should be affirmed. On good cause, the claimant was not prevented from attending the hearing due to circumstances beyond his control. Accordingly, he did not have good cause for his non-appearance. As to the separation, the weight of the available evidence established that the claimant solicited money in a manner that violated the employer's policy, which amounts to misconduct connected with the work. We should therefore affirm the AT decision. The claimant did not have good cause for its non-appearance. Misconduct, void the chargeback ruling.
Good cause should be found, and this case should be resubmitted. The claimant offered credible testimony that he did not attend the AT1 hearing due to his uncle's death. Because this was a circumstance beyond the claimant's control that prevented him from attending the hearing, a good cause should be found, and the case should be resubmitted to summarize the underlying merits testimony. Therefore, modify the AT, good cause, resubmit.
We will resubmit the case.
Case number 3780427, Chairman Esparza.
The AT's decision should be reversed. When the final incident occurred, the claimant was on a final warning tied to the bullying and harassment policy. Despite this, the claimant ensued in a verbal altercation with a coworker. This led to a formal investigation followed by the claimant's discharge. As the claimant mismanaged his position of employment by violating this policy again, his discharge was due to misconduct connected with the work. Reverse the AT decision, misconduct, no chargeback, adequate employer response.
The AT decision should be affirmed. The employer discharged the claimant and alleged that he was the aggressor in a verbal altercation with the coworker. However, the claimant provided credible and consistent firsthand testimony, which established that he and a coworker argued after the coworker moved the complainant's things, and the coworker then threatened the claimant's life, at which time the claimant reported the situation to the employer. The employer's allegations that the complainant was the aggressor was based solely on secondhand hearsay testimony. Therefore, the employer has failed to meet its burden of proving that the complainant was discharged for misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
The claimant should be disqualified. The volume and weight of the employer's evidence, coupled with the claimant's testimony that the argument ensued because his coworker moved some of his items, is sufficient to find misconduct. Modify the AT, misconduct, no chargeback, adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 378, 3137, Chairman Esparza.
The AT decision should be affirmed. The claimant became separated when he missed too many days of work. While the claimant was the only party to provide testimony at the hearing, his testimony was inconsistent with his fact-finding statements. The claimant testified that he had received no prior warnings for attendance. However, in fact-finding statement, the claimant stated he was previously warned for his attendance. Moreover, the dates that the claimant provided for his absence in his testimony differed from those provided in the fact-finding statement. Because the claimant's testimony and fact-finding statements were inconsistent, and because the AT was in the best position to gauge the credibility of the claimant, the AT decision that the claimant left his work voluntarily without good cause connected with work is supportable. We should therefore affirm the AT decision, voluntary leaving, no chargeback.
AT decision should be reversed. The employer discharged the claimant based on allegations that he was a no call, no show for 3 days. However, the claimant's firsthand testimony established that he provided notice for each day that he was absent and had not received any prior warnings regarding his attendance. The employer did not appear at the hearing to provide testimony and did not establish that the claimant's absences violated any attendance policy. Therefore, the employer has failed to establish that the claimant was discharged for misconduct connected with the work. Reverse the AT, no misconduct, chargeback.
We should find that the claimant was discharged for reasons other than misconduct. The employer did not appear to offer evidence to rebut the claimant's assertions made under oath. Thus, they failed to carry their burden of proving that the claimant did not properly call out of work for 3 days as per their policy. Therefore, modify the AT, no misconduct, chargeback.
Short form dissent.
Yes, sir.
Case number 378, 4413, Commissioner Trevino.
The decision is correct. The employer discharged the claimant for giving the incorrect amount of medication to a client. While the claimant admitted that she administered the incorrect dose, she had only been recently assigned with administering medication for the last couple of months of her 12-year employment. And she testified that she did not have any medical training and had not received sufficient training on how to properly administer medication, resulting in her misinterpreting the prescribed dosage. Furthermore, the claimant was not only the individual responsible for administering the client's medication, and she had no prior warnings. Therefore, the employer did not meet its burden of showing that the claimant was discharged for misconduct connected with the work. Affirm the AT, no misconduct, bill reimbursing employer.
The AT's decision should be reversed. The claimant was discharged after giving a child an incorrect dosage of medication. The employer has presented evidence demonstrating that this was, in fact, within her job duties and training. As the claimant's failure to provide adequate medication endangers the well-being of child, the claimant failed to perform duties amounting to misconduct connected to the work. As such, we should reverse the AT decision, misconduct, reimbursing employer, not billed, adequate employer response.
The claimant should be disqualified. The claimant admits that she gave a child an incorrect dosage of medication. This mistake, though unintentional, put the child's health at risk. As such, the claimant was terminated for misconduct. Modify the AT, misconduct, reimbursing employer, not billed, adequate employer response.
Short form dissent, ma'am.
Yes, sir.
Case number 3849182, Commissioner Trevino.
The decision is correct. The claimant worked for a temporary staffing agency on a project with the client company for several years. When the complainant was notified that the assignment that she was working on had ended, she immediately reported back to the employer and informed them that she was available for additional work. However, she was informed that no additional work was available for a couple of months. Since the claimant immediately reported for reassignment and was not offered any additional work at the time, the claimant was laid off due to lack of work. Affirm the AT, no misconduct, chargeback.
The AT's decision should be reversed. The claimant voluntarily left her position of employment after failing to properly report back for reassignment. As the claimant was aware of the company policy and failed to report back as instructed, she did not make herself available for work and has resigned without good cause connected to the work. Reverse the AT decision, voluntary leaving, no chargeback, adequate employer response.
The claimant should be disqualified. The claimant failed to follow the employer's reasonable policy to make herself available for further work when she did not report in person and sign the employer's logbook the day after her assignment ended. As such, the claimant voluntarily quit without good cause. Therefore, modify the AT, voluntary leaving, no chargeback, adequate employer response.
Short form dissent, ma'am.
Yes, sir. And that was the last case pulled for additional discussion on docket 4. You should have received the UI short form dissent list for docket 4.
I move that we accept staff recommendations on the remaining UI cases on docket 4.
I second the motion except for those cases which I am dissenting as reflected on UI short form dissent list for docket 4.
I concur with the Commissioner's motion except for the cases on which I'm dissenting as reflected in UI short form dissent list for docket 4.
The motion passes with the exceptions noted, and that concludes our business on agenda items 3 through 8. Chairman Esparza, I turn the meeting back over to you.
Thank you, Commissioner Connett. We will pause for the shuffle, and thank you very much for this.
Thank you, commissioners.
Yeah.
Okay, let's restart with item 9 regarding recertification as community rehabilitation programs. Mr. Garcia.
Good morning, Commissioners. Mr. Townsend, Chris, I'm sorry. I thought Randy was here. Juan Garcia with the Voc Rehab Division. This morning for your consideration and approval, we have 4 CRPs that are applying for recertification to continue participating in the Purchasing for People with Disabilities program. The CRPs are as follows. Texas Alcoholism Foundation, or otherwise known as Texas House, out of Houston. The San Antonio State Supported Living Center in San Antonio, the Lufkin State Supported Living Center in Lufkin, and the Corpus Christi State Supported Living Center in Corpus Christi. Staff recommends the recertification of the 4 CRPs as presented in the discussion paper. With that, I can answer any questions you might have.
Thank you, Juan. Commissioners, anything, comments or questions?
None here.
Chairman, I'd just like to thank Mr. Garcia for the work you and your office have done in preparing this and getting it to the commission for our ultimate approval. Thanks as well. I had a number of questions in advance of this meeting. You were very responsive and helpful with those, so thank you.
All right, thank you.
Thank you, Mon. Is there any, do I have a motion?
Chairman, I move that we approve the certifications and recertifications of the following community rehabilitation programs for participation in the Purchasing from People with Disabilities program as recommended today by staff. The recertification of Texas Alcoholism Foundation, San Antonio State Supported Living Center, Lufkin State Supported Living Center, and Corpus Christi State Supported Living Center.
I second the motion.
I also vote yes, motion passes. Thank you, Mr. Garcia.
Thank you.
Reed, come on up. The item 10 regarding publication for public comment of proposed amendments to the Texas Industry Recognized Apprenticeship Program. A lot of P's. Hey, Reed.
Yes, good morning, Chairman Esparza and Commissioner Trevino and Commissioner Connett and Mr. Nelson. For the record, I'm Reed O'Brien with the Office of General Counsel. Commissioners, before you today for your consideration for approval are proposed rule amendments to Chapter 838, Texas Industry Recognized Apprenticeship Grant Program. The proposed rule changes will implement House Bill 3260 passed by the 89th Texas Legislature. And that bill amended Chapter 302 of the Texas Labor Code to allow TWC to issue reimbursement payments to eligible grant recipients as program participants achieve on-the-job training and employment milestones instead of after they have completed the program. The legislation also requires the Commission to adopt rules establishing a process for and criteria by which TWC recognizes apprenticeable occupations and certifies training programs, and for setting performance metrics and making aggregated performance data available via the agency's website. Staff recommends submitting the proposed rule for publication in the Texas Register for a 30-day public comment period. And staff also requests the ability to make minor non-substantive changes to comply with the Texas Register and Office of the Secretary of State's publication requirements. And that concludes my presentation. I'm available for any questions.
Thanks, Reed. Commissioners, any comments or questions?
Nothing here.
No, none here. Thank you.
Reed, I have some remarks and some questions, but again, I think I appreciate this and everything that we're doing to push this program. I know that the legislature had, we worked with the legislature to get it more access. In the effort to make this more accessible and more agile for the TIRA grant, my question is specifically if we have a process for certifying, recognizing occupations that are not on the state's top 25 targeted occupation lists or the DOL's registered occupations list. I know that TIRA is limited to that top 25 list. Is there any process for certifying occupations outside of those two lists?
All right, Chairman, I'm going to have to defer to the Workforce Development Division to respond to that question. Mary York is coming up.
Thank you, Reed.
Good morning, Commissioners. For the record, Mary York with the Workforce Development Division. So, Mr. Chairman, if I could, I'm going to restate the question and make sure I understand. Are you seeking greater clarity in terms of what occupations would potentially be included for the TIRA program beyond those that are available through the DOL registered apprenticeship list?
Yes, ma'am. Our ability to certify occupations not provided on those two, on the top 25 list, and also the DOL's registered occupation list, if we have a process to access those occupations.
So I believe that under the new rules, we will be evaluating occupations to see if they meet the requirements of an apprenticeship. So there are some basic requirements that are laid out in the rule before you in terms of it including, obviously on-the-job training, which is a key part of an apprenticeship, instruction, all of the things that are leading to a recognized license or credential. So we will go through a process to ensure that an occupation or the training program meets those requirements. applicants for an apprenticeable occupation. The other lists are sort of the foundation, maybe the starting point, so to speak. The rules also contemplate a guide where there will be the additional information on processes that applicants might take in order to seek a TIRA grant, as well as the occupations that would be included.
Okay.
And I think it is something that we would be consulting with the commission on as we add additional occupations to the list.
Okay. So mechanically, if we go forward with a motion to approve the amendments, would we still be able to work and talk about getting access to that?
Yes, sir.
As
Absolutely.
Okay.
And just as a reminder for anybody observing the meeting today, this is really just the first stage of the rulemaking process. These rules will now be posted for public comment. And, we anticipate receiving public comment from industry, which is fantastic. So as we receive that comment and take that into consideration, we'll also be coming back to the commission, and reporting back on that as well. So we may receive industry comment that also helps guide additional clarity in terms of the occupations.
Okay. So I know that the discussion on our IBC advisory committees is to help get this, or help get access to emerging occupations, and so that we can make it a little bit more agile. Is there any way that we would be able to include in the proposal rules, in those rules, the process for evaluating new occupations? Or
we can certainly do that.
Okay.
We can provide a little bit more clarity. We would, in the interest of serving industry, we would like to get the rules out for public comment sooner rather than later. So
Okay.
I would need to confer with Reed and the rest of the rulemaking team to determine, how long that might take in terms of the process of adding any additional information into the current document. The other thing I might note is, one of the reasons that we wanted that process included in the guide was, if we determine that we need to modify the process in any way, that the commission feels like we need to, make some changes, we would prefer not to go through the full rulemaking cycle, which obviously can take several months.
Okay.
So, we were hoping that we could be a little bit more nimble and responsive to industry by having that process outlined in the publicly available guide.
Okay. Is it massively detrimental if we hold this for next week, so that we can kind of
I don't think
get
so, sir.
clarity on
No,
putting
I
that
think
in?
that we can hold it for 1 week.
Do I need to make a motion to do that? Or do we hold? Okay, commissioners, if you may, I'd like to move to postpone this item to next week, so that we can look at what we talked about, try to get access to off the list occupations.
Okay, I'll second.
Yeah, I'll vote yes on that motion. Thanks.
Thank you.
Okay, thank you. Motion passes. Reed, thank you very much. Appreciate it.
Yes, sir. Thank you. And I've got the next one as well.
Yes, you hang out there. Thanks, Mary. She left. Item 11 regarding publication for public comment on Chapter 858, procurement and contract management requirements for purchase of goods and services for vocational rehabilitation services. Mr. Reed.
All right, Chairman, Commissioners, and Mr. Nelson. Again, for the record, I'm Reed O'Brien with the Office of General Counsel. Commissioners, before you today for your consideration for approval are proposed rule amendments to Chapter 858, procurement and contract management requirements for purchase of goods and services for vocational rehabilitation services. The proposed rule changes will implement House Bill 2791 passed by the 89th Texas Legislature. The bill amended Chapter 352 of the Texas Labor Code to provide TWC direct and explicit statutory authority to procure goods and services for the vocational rehabilitation program. including the continued use of the open enrollment solicitations and a new authority for direct negotiation with qualified vendors. Staff recommends submitting the proposed rule for publication in the Texas Register for a 30-day public comment, and staff also requests the ability to make minor non-substantive changes to the document to comply with the Texas Register and Office of the Secretary of State's publication requirements. And that concludes my presentation. I'm available for any questions.
Thank you, Reed. Commissioners, any comments or questions?
None here.
No, none. Thank you.
No questions for me. Thank you. Is there a motion?
Chairman, I move that we approve the proposed amendments to 40 Texas Administrative Code, Chapter 858, Procurement and Contract Management Requirements for purchase of goods and services for vocational rehabilitation services for publication for public comment as recommended today by staff.
Second.
I also vote yes. Motion passes. Thank you, Reed.
All right, thank you.
You now depart. Item 12 regarding AEL annual report.
Good morning, Chairman Esparza, Commissioner Trevino, Commissioner Connett, and Mr. Nelson. For the record, Mahalia Baldini, Workforce Development Division. Texas Labor Code 315.005 requires that the Texas Workforce Commission establish an Adult Education Advisory Committee, which is charged with reporting to the Commission annually and advising the Commission on various aspects related to the enhancement of adult education in Texas. I want to take a moment to thank all of our advisory committee members for their contributions over the last year that led to today's report. I especially want to thank Janine Maldonado, who served as our presiding officer over the last 2 years and who was supposed to actually present with me today. But due to the weather event and some scheduling conflict, she was unable to join me. Over the past year, our advisory committee has focused its work on shaping the development of our new AEL strategic plan, which will come before the Commission later this summer. This year's report outlines the work of the committee to ensure that our plan considers the landscape of workforce and economic development in our state and the agency's commitment to having a literate Texas. At this time, I'm going to read some remarks from our advisory committee for the commissioners. As outlined in your notebook materials, the Adult Education and Literacy Advisory Committee convened 4 virtual meetings this year to advance strategies that enhance program effectiveness and align the Texas Workforce Commission's mission. The report identifies the major focus for this year was to develop our new AEL strategic plan for fiscal years 2027 through 2031. The updated plan centers on 3 system strategies: learners, employers, and partners, each with defined strategies, objectives, and measurable benchmarks to ensure that accountability and quality improvement are at the forefront. While all 3 areas share common objectives, the action items will be tailored to specific needs and priorities for each of these system strategies. Additionally, the indicators and benchmarks will also be developed uniquely for each area. Key initiatives discussed throughout the year include the implementation of quantitative metrics and creating a public-facing dashboard to track progress and promote transparency. The committee also learned about a resource, the Career Pathways Professional Development Center's Employer Connect Hub. This is designed to promote AEL services, strengthen partnerships, and align workforce training with industry needs. This Employer Connect Hub was actually a recommendation by the committee from last year. So it's showing that we are, as an agency, being responsive to the committee's recommendations. So we have launched that. And the strategic plan is currently in the final stages and is scheduled for completion by August of 2026. These initiatives aim to improve learner outcomes, foster collaboration, and ensure AEL programs meet Texas employer needs. That concludes my remarks about the report, and I'm happy to answer any questions that you may have.
Very good. Thank you very much. Commissioners, any comments or questions?
No, just thank you, Mahalia, for all you do and for the committee. Great work.
Yeah, Chairman, just a comment. Mahali, I want to second your thanks for the members of this advisory committee. The work of the agency and the commission is much stronger, much more thoughtful and better for the Texans we serve, thanks to their dedication of time and energy, efforts and expertise. So really appreciate all that they do. Also want to thank you and Mary. I had a number of questions in the run up to this meeting about the committee, its work, and AEL generally, as you recall, including questions about accountability and quality. You all were very prompt and responsive in answering those. So I thank you for your subject matter expertise and professionalism. Thank you.
Thank you, Molly. No questions on this. Thank you for the presentation.
Thank you.
Action needed. Item 13 regarding approval of local workforce development board nominees.
Good morning, Chairman, Commissioners, and Mr. Nelson. For the record, Kara Levy with Workforce Development Division. Today, for your consideration, we have workforce board nominations for the following boards: Workforce Solutions Greater Dallas and Workforce Solutions Southeast Texas. Staff present these nominations for your consideration, and I'm happy to answer any questions you have.
Very good. Commissioners, any comments or questions?
Nothing here.
No, none.
Is there a motion?
Chairman, I move that we approve the local workforce development board member nominees presented today for Workforce Solutions Greater Dallas and Southeast Texas.
And I second the motion.
I also vote yes. Motion passes. Thanks, Gary. Item 14 regarding acceptance of pledges for board contract years and child care matching funds.
Good afternoon, Chair, Commissioners, Mr. Nelson. For the record, sorry about that, Stephen Sager, Workforce Development Division. In accordance with federal regulations and TWC Chapter 809 Child Care Services Rule, TWC encourages local workforce boards to secure and submit local matching funds to TWC in order to receive a portion of CCDF funding. Today, we bring our second round of BCY 26 match agreements for commission approval. The supporting documents will include 45 BCY 2026 match agreements from 13 boards: Central Texas, Concho Valley, Golden Crescent, Greater Dallas, Gulf Coast, Lower Rio Grande Valley, Panhandle, Permian Basin, South Plains, South Texas, Southeast Texas, Tarrant County, and West Central Texas, totaling $12,824,555. Boards have secured 43.35% of the statewide child care local match for BCY 26. I'm happy to answer any questions.
Thanks, Stephen. Commissioners, any comments or questions?
Nothing here.
None here. Thank you.
Is there a motion?
Chairman, I move that we approve the acceptance of child care pledges for donations, transfers, and certifications of expenses for board contract year 2026 in the amount of $12,824,555 as recommended today by staff.
And I second that motion.
I also vote yes. Motion passes. Thank you very much. Steve. On to reports. Michael's our ledge report. Come on up.
Good morning, Mr. Chairman, Commissioners. Mr. Nelson, for the record, Michael Britt, Governmental Relations. Last week, the U.S. House passed H.R. 7148, the Consolidated Appropriations Act of 2026. This bill includes funding for the remainder of fiscal year 2026 for the Departments of Labor, Health and Human Services, and Education, the Department of Defense, and Departments of Transportation and Housing and Urban Development. This bill was combined with several other appropriation titles also passed by the U.S. House last week, and those were all sent to the U.S. Senate for their action. Currently, the U.S. Senate is scheduled to take a procedural vote on this combined appropriations package tomorrow for their consideration. Just as a reminder, current federal government funding expires at midnight this Friday, January 30th. If the Senate were to make any changes to the appropriations package before them, it will need to go back before the U.S. House for their consideration. And as of right now, the U.S. House is currently in recess this week and is currently scheduled to reconvene on Monday. So we'll be keeping your offices up to date as this package moves through the Senate the rest of this week. That concludes my remarks. I'm happy to answer any questions that you have.
Thank you, Michael. Commissioners, any comments or questions?
Nothing here.
No, nothing here. Thanks for keeping a close eye on that.
Appreciate it. Thank you,
Thank
Michael. Chris, we got anything for item 18?
We do. Good morning, Chairman, Commissioners. For the record, Chris Nelson sitting in for Randy Townsend. We have a few updates this morning for you. First off, Mary York is going to give an update on the state of Texas application.
Good morning again, Mr. Chairman, Commissioner Trevino, and Commissioner Connett, and Mr. Nelson. This weekend, TWC rolled out a new version of the State of Texas application on our workintexas.com job matching site. So previously, Texans applying for state jobs were required to complete a lengthy form that included fields such as typing speed and skill with office equipment. They were asked to complete their education and employment history for the application, often having to copy it off of an external resume. With the change this week, we have streamlined the process to remove outdated questions and are now requiring a resume instead of asking for that information on our own form. If an applicant does not have a current resume, the Work in Texas system offers the option to create a resume using a resume wizard or using an artificial intelligence powered resume builder. Our fellow state agencies have received information on this update over the last few months, and many have expressed their appreciation for the change. In 2025, there were approximately 88,000 applications submitted for state jobs in Work in Texas. And we believe that the new process will make applying for state positions simpler and help state agencies provide a hiring experience more comparable to that of private employers, which will hopefully increase that number of applications even more. I'd like to acknowledge the hard work of the team who worked on this project, including the staff and leadership in workforce automation, information technology, and human resources, as well as our partners in those other state agencies who gave us feedback during the process on what was important to them. So between all of the requirements, working with the vendor, communicating with stakeholders, all of that was definitely a team effort. And I think that they deserve some accolades. So with that, I am happy to answer any questions you may have.
Commissioners, any comments or questions?
Nothing, but just agree with you, Mary, if you could pass on the accolades to the staff and the team that worked hard on this.
Yeah, it's second that great work by you and the team, Mary. I don't mind stating for the record that I don't know my typing speed and my proficiency with a fax machine is probably mixed at best. So this modernization and simplification is really exciting. Thanks for presenting it.
Thank you. Mary, just one question. Anybody that's current job seekers that are currently involved in the process, are they updating their application, or is it mandatory that they fill out another application to get into the system to update it?
So there are a couple of pieces of good news there. So
Yeah.
obviously, if they've already applied for a job, then that application was already transmitted to the state agency to which they applied. If they're applying for a new state job, then they will need to fill out a new application. However, one of the things that we have programmed into the new format is it pre-populates many of those fields for you. So since they have already applied for other state jobs, they would have completed their user profile, and that includes things like name and, contact information, things like that. So that's going to pre-populate in the system, and all they're doing is confirming. It's really as simple as hitting a button and just confirming the fields that are already in there, and then uploading that resume. And again, there are some AI tools that are available to them if for some reason they don't have a resume.
Okay. Great. Yeah. I join my commissioners in saying thank you all to all the hard work that you guys are doing to improve our system. So, Mary, thank you very much.
A couple other updates for you. In coordination with Health and Human Services, we are on track to submit the first report to the governor's office regarding the child care program this week as required. And second, staff have been meeting and developing an action plan to comply with the governor's directive issued yesterday on H-1B visas, and we'll keep you updated as we continue to make progress. And as usual, this agency is full of dedicated employees that have been able to move quickly to address these issues raised by the governor.
Great. Thanks, Chris, and all the work that you guys are doing in meetings to answer these directions. We appreciate that. Commissioners, anything else?
No.
I believe we have come to the end of our agenda, and surprise, we have no executive session to announce. So everybody, praise God for that. Is there a motion?
Chairman, I move to adjourn.
And I second.
Motion is made and seconded. I also say, let's get out of here. Agenda's over. Thank y'all.